brought to you by the Boca Chamber. We are extremely excited today to have Ellen Leibovitch be our speaker today, and she's going to be speaking on what employers need to know about COVID-19 under the new federal law. So I know we've been making phone calls to our members, and our members have been asking tons of questions related to this topic. So we're super excited that she's able to present this today. I'm going to introduce Ellen. I'm going to read her bio. Ellen Leibovitch is Florida Bar Board Certified Labor and Employment Attorney and heads the labor and employment practice of Assouline and Berlowe. Ms. Leibovitch focuses her practice on labor and employment law, counseling, and litigation, and has significant bench and jury trial experience. She litigates cases in state and federal courts and represents clients at governmental agency proceedings. Ms. Leibovitch is a member of the Executive Committee of the South Palm Beach County Bar Association, is a past president of the South Palm Beach County chapter of the Florida Association for Women and Lawyers, and serves on the Florida Bar Labor and Employment Certification Committee. Ms. Leibovitch has been named a leader in the law by the Florida Association for Women Lawyers, a top attorney in Florida by the Wall Street Journal, and Florida super lawyer by Thomas Reuters. I apologize, I actually forgot before we have Ellen speak real quickly. Some of you guys are going to want to have questions during her presentation. Ellen stated that she welcomes questions after her slide. So if you want to ask any questions, you can just put it in your chat section of the Zoom, which is in your bottom toolbar menu, and you can put them to Sophia and she will read them out to you. Well, she'll read them out to Ellen and Ellen will answer the questions. So without further ado, take it away, Ellen.
Okay, great. Thank you, Chastity. Welcome, everyone. Good morning. I hope everyone is safe and healthy and exercising proper social distancing. I wanted to talk to you today about the impact of the COVID-19 virus and how it has resulted in a new federal law that is intended to help employees to be able to take some emergency family medical leave and sick leave. And we'll touch on a few other topics. I am available after this. If you have any further questions, I'm happy to take questions as we go along here. Try to keep your questions as general as possible relating to the subject matter, but if you have any specific questions after we're done, like I said, I am very happy. You're going to have my email address and anyone can email me and ask me a question, and I will try to answer you as quickly and succinctly as possible. Okay, let's go to the first slide, Sophia. Okay, so the new federal law is called the Family First Coronavirus Response Act, and we're going to either call it the FFCRA or the Act. And as I mentioned earlier, this is the act that expands family and medical leave to address medical leave necessitated by the virus, and also provides federally mandated and paid sick leave. Some of you may be familiar with the Family and Medical Leave Act, and we're going to talk a little bit more about that. That is only applicable to employers that have over 50 employees. This amended emergency portion of the Family Medical Leave Act is much more expansive, and we're going to get into that. Now, there's another new law. It's called the Coronavirus Aid, Relief, and Economic Securities Act. Many of you may have heard about it. You probably have been reading things about it. That's called the CARES Act. That was the one that was just signed into law on Friday, March 27th, and that's going to provide a lot of economic relief to businesses and individuals. That includes loans, tax relief, cash payments to individuals, and enhanced unemployment benefits. I'm sure that probably you've heard about the $600 increase per week through July 31st for unemployment benefits. We're not going to be focusing on the CARES Act today. I understand that there is going to be additional chamber support for understanding this act, but I just wanted to mention it to you because that's another act that's been out there. There's a lot of legislation that's going on out there as Congress is attempting to respond to this crisis and to address the needs of not only employees, but also employers, because there is no way that we are going to be able to survive this if we cannot continue doing business and engaging in commerce. So more on the CARES Act, but today we're going to focus on the Family First Coronavirus Response Act. Okay, next slide, Sophia. Okay, so today what I'm going to try to do is I'm going to try to provide you guidance to employers who have to face issues of whether or not to provide leave to their employees. And I understand that a lot of people have been contacting the chamber. I can tell you a lot of my clients and people that are not my clients, but who just need some advice because they're trying to wade through these new laws. Everyone is confused. The confusion is understandable. I have to be honest with you, as things progress day by day, we're getting more and more guidance from the Department of Labor about how to interpret this act and how to advise our clients. So just recognize that you're not alone if you have questions, but I'm going to try to provide you guidance to help you work through these issues. And to also help you understand your financial obligations to employees, because not every type of leave creates a financial obligation to the employee. And again, I'm going to try to address some of the most frequently asked questions about the mechanics. And these are questions that I know are frequently asked because I'm asked them at least 10 times a day. So I'm sure that you probably have similar questions as well. We are not going to be discussing employers with a unionized workforce to which different rules may apply based on collective bargaining agreements. And we're also not going to address issues relevant to healthcare providers or first responders. And I'm going to get into that a little bit more as we progress, because those industries can be exempted from the emergency family leave and sick leave under the FFCRA. So with that in mind, I'm going to move forward. I know that I just saw a couple of questions. I think that it's, Sophia, if you want to tell me what the question is, I'll tell you whether we're going to get to it later and we can put a hold on it.
Yes, so we have a question. Does a small employer under 50 employees still have to post a flyer about the benefits of Family First Act if it would jeopardize the feasibility of the company?
We are going to get to all of those questions. So just sit tight and let's get into the weeds a little bit. And if I don't answer anything, we definitely will have time at the end to address anything if I haven't. Okay. So today is when the act goes into effect, and it is only set to last until December 31, 2020. And that's based on what we know now of the virus, where it's going, how long it's going to last. There's always a possibility that this deadline is going to extend beyond December 31, 2020, but we just don't know that now. So for right now, we know that the act goes into effect today and is going to stay into effect through the end of the year. And it is applicable to employers with fewer than 500 employees. So remember I told you before about the FMLA, the Family Medical Leave Act, was only applicable to employers with less than 50 or more employees. This one is less than 500 employees. So that's bringing a lot more employers into the fold. And the two main provisions of the act that we're going to talk about are emergency family and medical leave and paid sick leave. There's another big aspect of the act which provides additional funding for unemployment offices in the states to get more funding to be able to support them as the unemployment rate rises. We're not going to really talk about that. We're just going to talk about emergency family, medical leave, and paid sick leave. Okay, any questions, or can we move on, Sophia? Okay, so as I mentioned, the act does not apply to employers with over 500 employees. And I will say that the Family and Medical Leave Act, which applied to employers with over 50 employees, didn't apply to that many employers in the state of Florida. It applied to a lot, but not all of them. This is over 500 employers. employees, which means that this is going to be covering a lot more employers. So all employers really need to know about this. And when you look at the 500 employee threshold, you basically have to count everybody: active, full-time, employees on leave, temporary employees, day laborers, employed by a temporary agency. Basically, anybody is going to be counted. But if you're anywhere near that 500 employee threshold where you may not be exempted, where you may not be included, you know, it's worth looking at it. But if you're anywhere under 500, you're going to be covered. Okay, Sophia, any questions, or can we move on?
No, we can't. We have a two-part question here.
Okay.
So does an employee have to provide proof that they have the virus if they want to get paid? And if they can't get the doctor and can't have the test, how can they do this? Are there dates involved? If they were sick before a certain date, is it applicable?
We're going to get that when we talk about the specific types of leave. So maybe we can just put a pin in that question for the moment, okay?
Gotcha.
Okay, let's go to the next slide. So what I am advising people, employers, is that they have existing policies. If they have paid time off policies, if they have leaves of absence policies, if they have an FMLA leave policy already existing, they need to make sure to do an addendum or otherwise notify their employees about the change in the law. And you're going to be able to do that through the poster, which we're going to talk about. But if you have a handbook, you may want to put something in your handbook as well. Again, remembering that this is only applicable until December 31, 2020. Okay, Sophia, can we move on? So the Act is amending the Family Medical Leave Act by providing 12 weeks of job-protected leave for employees who have been on the job for 30 days. So if we could compare this with regular FMLA leave. FMLA leave normally, not this emergency one, applies only to employers who have 50 or more employees. This is going to apply to a lot more employers, the less than 500 employees. Also, under the regular FMLA leave, an employee, in order to be eligible to take the leave, has to work for 1,250 hours in the year before their leave commences. This is saying that the employee only has to be employed for 30 days. So that's a huge difference. It doesn't say how many hours they have to work. They just need to be employed for 30 days, and then they are going to be eligible for leave under this emergency FMLA. Okay, anything, Sarah, or can we move on? Okay, so this is where we're starting to get into the specifics. The emergency leave under this emergency FMLA leave must be for an employee to care for a child if the child's school or place of care is closed due to the virus, or if a child care provider is unavailable due to the virus, or any related reasons. So basically what this is saying, we know that I believe, if not all, then certainly 99% of schools and daycare are closed. If that's the situation and you have an employee who needs to take care of their child because they have no other child care, then that employee is entitled to be taking up to 12 weeks of FMLA leave. The need for other types of leave, which is not related to child care, we're going to talk about in a little while. But the key provision of this FMLA leave is that it allows for up to 12 weeks to care for a child. Sarah, I'm sorry. Sophia, it looks like we have a question.
Yes, so if someone is already home with the child and one of our employees requests to stay home with their child due to the other parent working from home, will they be entitled to take the leave event though there is already a parent working from home?
Just because somebody is working from home doesn't mean they're able to take care of their child. Anybody who has children at home and tries to work from home knows that it could be very difficult, especially depending on the age of the child. I mean, if you have a very young child, you know, it's virtually impossible to work and to take care of your child. If you've got an older child and you've got to help that child with their schooling through virtual school, it's going to be really difficult for you to work. So the fact of the matter is just because there's somebody at home doesn't mean that they are able to take care of the child. So the reality is that second parent should be entitled to take their leave. Okay, Sophia, you want to move on? Okay, so the leave that's available is for up to 12 weeks total. That's the same as under the regular FMLA. Regular FMLA entitles employees to 12 weeks total leave unpaid. Now, under this emergency FMLA, the first 10 days are still unpaid, but as we're going to discuss in a moment, it can be paid as sick leave. So just think about that for 1 second, and we'll put a pin on it for right now. The next 10 weeks is paid. So if you've got 12 weeks total, you've got the first 2 weeks that are going to be unpaid, but we're going to be paying them as sick leave, not as FMLA leave. And the next 10 weeks is paid at 2/3 of the employee's usual rate of pay. But with respect to the usual rate of pay, the law states that you are not going to be required as an employer to pay more than $200 a day and more than $10,000 total for the FMLA leave. Okay, Sophia, anything, or can we move on?
No questions right now.
Okay. Now, as I mentioned, we're not going to be, did we miss one? Okay. Employees taking this leave have the right to be reinstated, and that's the same thing that's under the regular FMLA leave. If an employee goes out on this emergency FMLA leave, they have a right to reinstatement to a position, not necessarily their same position, but to a position that offers them equal pay and benefits. But if you've got an employer that has less than 25 employees and you can show that the position that the employee held when their leave commenced no longer exists, or that they would have otherwise been terminated, then you are not required to reinstate that employee. So if you've got an employee that is out on FMLA leave and the position is eliminated during the leave, the employee has no right to reinstatement. The employee is going to have other rights, and we're going to talk about that as far as filing for unemployment, but you have to be able to show that that position no longer exists. And there's really no criteria now that explains what those economic conditions or changes of operation are going to look like. But suffice it to say that if you've got a business that basically is no longer able to do business because you don't have customers, because you can't collect on your receivables, because employees aren't coming to work for any reason, you basically have to cease business operations or cut them down so much that, you know, most all of the employees are laid off, then you are not required to reinstate for fewer than 25 employees. And we're going to talk about other exemptions later on, but this is for fewer than 25 employees, because let's face it, this is a real economic burden on employers, and for employers that have less than 25 employees, it's going to be a huge financial burden on them.
Ellen, we have a question.
Yes.
Are these federally taxed?
I don't understand that question.
Let me ask her to be more specific.
And if it's a question regarding, you know, taxation in terms of, you know, how these leave benefits and sick leave benefits are going to be taxed, I really don't think that I'm the person to be answering that question. I would recommend contacting a financial advisor or tax consultant. Do we have any clarification, Sophia, or can we move on?
I'm waiting for her to type back, but we can come back to that question. We'll move on.
Okay, that's fine. Okay, so Again, we're not going to talk about the emergency responders or healthcare providers, employees, because they can be exempted from emergency FMLA leave. I did mention that employers with less than 50 employees can also be exempted from the requirements, and we're going to talk a lot about that going forward because that also applies to exemption from sick leave as well. The Department of Labor has just issued some guidance about getting exemptions, which is what we're going to discuss later. But I have to be honest with you, it is far from clear as to what is going to be the exemption process and what employers are supposed to do in the interim. So we're going to talk about that towards the end of the presentation. So we'll come back to that one. Any questions, Sophia, or can we move on?
We can move on.
Okay. So that was the FMLA portion of the FFCRA. Now, this is by far the most important provision of the law because it applies to a lot more cases. This is the provision of the law that allows paid sick leaves. And depending on the nature of the leave is going to depend on how much the employer is going to have to pay. But any way you slice it, paid sick leave is limited to 2 weeks only. And that's for a governmental quarantine or isolation order. And that has to be a legally enforceable order, not just a recommendation to stay at home. There has to literally be a government-issued order. Advice from a healthcare provider to self-quarantine due to concerns. If you think that you've got symptoms that may make you susceptible and you may be testing positive for the virus, you are going to be getting sick leave. If you are an employee who experiences symptoms and you feel that you need to go to a doctor, you can also take sick leave. Next slide, Sophia. If you need to care for or assist somebody else who is subject to the government or isolation order or has been advised by a healthcare provider to self-quarantine, this is people that are elderly or infirm, or if you have, a loved one that you need to be available to assist them because they come within either category 1 or 2 of the sick leave criteria. Number 5 is the need to care for a child, which is the same thing as under the FMLA leave. And number 6 is kind of an interesting one. It's kind of a catch-all, is experiencing other conditions specified. There's really no guidance on that. So to the extent that you've got some medical condition and you don't know whether or not it could or could not be related to the virus, arguably you should be entitled to sick leave under this law because there's really no guidance provided as to what exactly are those conditions. And there's a lot of conditions that can overlap and may very well be symptomatic of the virus. So I like to call this the catch-all provision. Now, to determine, I'm sorry, go back one sec, Sophia. On the bottom where it says determining the need for the sick leave, and these are the reasons that we've gone through, 1, 2, 3, 4, 5, 6, is critical to determining how much the employer is obligated to pay the employee when they are out of work. Okay, now you can move on. Okay. So, employees who are seeking leave for the first 3 reasons, and that was the governmental quarantine, the advice from the healthcare provider, or they're experiencing symptoms of the coronavirus, the employer is obligated to pay up to $511 per day or $510 total for 10 days. Now, let me explain that a little bit more in detail. If you have an employee that is earning whatever that employee is earning, you only have to pay them what that employee would normally be earning for the days that they are out sick. Just because it says $511 a day doesn't mean that that is your obligation. What the $511 per day means is that is the maximum of your obligation. And the $5,110 total is for the full 10 days. If you have an employee with reasons 1 to 3 that's out only 3 days, you're only obligated to pay them for 3 days. Now, that means that they still have another 7 days banked until the end of the year, but you're only obligated to pay them for the days that they're out, and you're only obligated to pay them up to their regular rate of pay. Similarly, if you've got employees that are out because they need to care for a child, or need to care for another individual who's subject to this government quarantine order, or has been advised by a healthcare provider to self-quarantine, or if they are experiencing other conditions, the maximum amount that those employees to be paid is $200 a day, or $2,000 total if they're out the entire 10 days. But again, you have to look at what the employee's regular rate of pay is, and you are only obligated to pay them what they would normally have been paid had they been working. You're not obligated to pay them $200 a day if they don't make that amount. If they make more than that, then they're only going to get $200 a day. Reason number 5, which is the child care, that's the one that overlaps with the FMLA. So as I told you, the first 2 weeks of FMLA are unpaid. They are paid through the paid sick leave. So that's how these two acts work together to ensure that someone who's out for 12 weeks is going to get 2 weeks of paid sick leave and then 10 weeks of paid FMLA leave. And again, just remember that the employee is only to be paid up to $200 a day, but they are not required to be paid $200 a day, just their regular rate of pay. And we're going to also talk about what that means in terms of partial payment, because that's going to come into play. This is full payment. The 2 weeks of sick leave is full payment. The additional FMLA leave is going to be a little bit different. No minimum period of employment is required for sick leave. Remember, emergency FMLA leave, I said you had to be employed for 30 days. There is no minimum length of service required for emergency paid sick leave. Sophia, do we have any questions?
No questions right now. Is it okay if we move on?
Yes, let's move on. Okay, so the 80 hours is for full-time employees. So we're still just talking about the emergency paid sick leave. So if you've got a full-time employee that is eligible to be taking sick leave, they are entitled to take up to 80 hours, which is 2 weeks. That's for full-time employees. Now, part-time employees are also going to be paid for whatever time they would normally be working. So part-time employees don't work a normal 40-hour work week. They may only work 20 hours and they may only work 30 hours. The obligation to pay sick leave is only based on what that employee's schedule would normally look like over a 2-week period. And if you have questions as far as computing the amount to be paid to part-time employees, I would recommend you look back at a certain period of time. If it's less than 6 months that they've been employed, look at the entire time that they've been working, 6 months, and take an average of what they work over 2 weeks. If they've been working more than 6 months, I would say look at the average of what they've worked the last 6 months. Employers cannot require employees to use other paid leave or, for example, vacation. They're not required to, they're not allowed to require their employees to use other paid leave as a substitute for the emergency sick time. And they're also not allowed to require employees who request paid sick time off to get someone else to cover for their schedule. I understand that that's a big issue in the food service industry. So this law is saying that the employee is not required to get anybody to cover for their shift, but they're also not required to make their employees use paid time off as a substitute for this emergency paid sick time. Did we have a question, Sarah?
Hi, Ellen. Yes. So if we bring in 1099 contractors at this time, are they eligible for these benefits?
Contractors are not employees. These are applicable only to employees. So that's important to know. And these employees, have to still be employed by April 1, because that's, as of today, is when the law goes into effect. If you had employees who were working for you that were terminated last week, they're not eligible for any of the relief under this act. And again, this is only for employees. It's not for independent contractors.
Thank you. That
Anything
was the
else?
only question.
Okay, let's move on then. So going along with the comment about not being required to use paid time off, it's important to remember that this sick leave is in addition to any other sick leave or any other paid leave or anything else that the employer offers. That's the reason why I recommend that if you have an employee handbook, it's a good idea to update the employee handbook to include these benefits so that it's clear that this is in addition to whatever benefits the employee is otherwise entitled to. So if you've got an employee who, as we sit here today, on April 1st, has already used all other sick leave to which they were entitled from the employer, they're still entitled to this benefit. However, any sick leave that's unused under this emergency paid sick leave is going to expire on December 31. So if employees don't use that, it does not carry over. Other paid time off or other sick leave benefits may carry over under the employer's policies, but under the law, this sick leave does not carry over after December 31. And again, just as with the FMLA, employers of healthcare providers and first responders may elect to exempt employees from this benefit. Okay, anything, Sarah? Sophia? Okay. Interestingly enough, this provision, this new sick leave contains anti-retaliation provisions, which are basically saying that an employer cannot take any type of action against an employee who seeks to take emergency sick leave or who files a complaint against an employer related to this act, or is testifying in any proceeding, even if they're giving a deposition in connection with this act. This is a normal anti-retaliation provision, and there is also an anti-retaliation provision that currently exists under the regular FMLA, so arguably the same anti-retaliation that's under the FMLA would also apply to the emergency FMLA, but because this is a totally new area of law for the government to get involved in, they've included anti-retaliation measures. And the reason for that is significant because if an employer is found to have violated the Emergency Paid Sick Leave Act, they're going to be required to pay damages equal to minimum wages, as well as other penalties and double damages for willful violations. This is very similar to the same type of penalties and relief that's entitled to employees who don't get paid overtime or minimum wage under the Fair Labor Standards Act. So this is just some teeth that the government has put into the law to kind of dissuade employers from not complying and giving employees a private right of action against any employer who does not comply. Did we have a question, Sophia?
Yes, I have a two-part question. Are we allowed to request a doctor's note from anyone who wants to take time off based on reasons 2 to 4? And are we also allowed to request a return to work note that clears them to return?
For number 2 and 4?
Yes.
Yes. The government, the law, the way that it's written, some privacy is given up in exchange for these benefits. So if an employer has a reason to believe that the employee may be taking advantage and is not actually seeking a medical diagnosis or is otherwise seeking paid sick leave for reasons that are not true, you have the right to request that documentation. And you just need to understand that getting those doctor's notes and having the communications with doctors may not be as easy as it usually is, So my only advice is, while you can request that, and you should request it, especially if you have an employee that's got either a proven track record of taking advantage or not necessarily being the best employee or the most reliable or the most honest, or you have a brand new employee and you just want to make sure that they are being totally upfront with you, just recognize that some patience is required in terms of getting documentation. So while you can ask, just be patient in terms of getting the information requested, or let the person know at the beginning of the leave what you're going to be requiring before they're able to return to work, so that maybe they can line that up in advance.
Thank you. That is the only question right now.
Okay, let's move on. Okay, so I put together this little shorthand guide, which is kind of what I like to think of as sort of a checklist. So every situation has to be analyzed based on that specific situation. So if you have somebody who can work, and this is either because they're working in your office or they're able to work remotely and has no reason to take leave, they should continue to do their normal job, and they could continue to be paid their normal compensation, and they are not entitled to any leave under the Act. Okay? So that's the best case scenario. If you've got employees that can work either remotely or come into the office and work safely, they don't get their leave. Now, if there's a government-ordered shelter-in-place or quarantine, which we have not seen yet, an employee who cannot work, and when I say work, I not only mean work in the office, which they couldn't if there was a quarantine order, but they couldn't telework, then that employee should get sick leave paid paid at 100% as of April 1. Now, if you have an employee who's sick and needs to go to the doctor, that employee can get up to 2 weeks sick leave as of today. If you want to request a note from the doctor to verify that the employee went there, you can do that. If an employee requests leave for sick leave because they say that they're sick and they need to go to the doctor, you should probably let the employee know at the outset to get some sort of doctor's note to verify how long that employee is going to be needing to be out of work. Obviously, if somebody goes to the doctor because they're feeling sick and they're able to come back to work the next day, that's not going to be an issue. The issue is if the leave is going to be extended and they're going to be seeking this paid sick leave. Similarly, if an employee has been ordered by a doctor to stay at home and you want to get verification that that doctor's order was put in place, that employee can get up to 2 weeks of paid sick leave, 100% as of April 1st. Now, again, 2 weeks is just the maximum. It doesn't mean that an employee should be out the entire 2 weeks, or that you as an employer are required to pay them for 2 weeks. You're only required to pay them for the length of time they need to be out, up to 2 weeks. Now, employees who need to stay out longer than 2 weeks because they have a serious medical condition. Like, for example, let's say you've got an employee who actually tests positive for COVID-19. These employees are not required to be paid after the 2 weeks. If you are an employer to which the FMLA, the normal FMLA, which applies to employers with over 50 employees within a 75-mile radius, and that employee is otherwise eligible to be taking FMLA leave, that employee should be offered FMLA leave, which is unpaid for an additional 10 weeks. Now, if you are an employer that is not governed by the FMLA because you do not have 50 employees within a 75-mile radius, then that employee who needs to be out for additional time due to this serious medical condition may have other relief available to them. For example, perhaps under a disability policy, whether it's an employer-sponsored disability policy or whether it's a private disability policy, but the employer's obligation to allow that employee to take a leave of absence until they get better and to keep their job does not exist. So just to be very, very clear, if you have a sick employee who otherwise would be entitled to FMLA leave, that FMLA leave should be offered to them. If you're not covered by the FMLA leave and your employee needs to be out longer than 2 weeks, their job is not protected. And you as the employer have the right to notify that employee that you cannot keep the job open, that you're going to have to terminate that employee, and that employee should apply for unemployment. Now, some employers have leave of absence policies. These are completely discretionary with the employer. If you've got such a policy, you should see what that policy says. And if you have questions about how to interpret that policy going forward to deal with these type of situations, that's something that I would be glad to help anyone work through that. But this is a really important area because a lot of people thought that this leave was going to be available to people that were sick longer than 2 weeks, but it's not. I see we have a question, Sophia.
No question right now.
Okay, no question. Okay, so let's continue with the shorthand guide, the next slide. So now if you've got an employee who is still under this quarantine order, the government quarantine order, and cannot work from home, if that employee can no longer work and the government quarantine order is still in place, that employee can be terminated and can file for unemployment. Now, if you have employees who are caring for someone under that government quarantine order, those employees get their paid sick leave up to $200 a day, but they are only eligible to be paid for 2/3 of what their normal pay would be. So you remember when I was telling you about the full pay for reasons 1, 2, and 3 for sick leave? These employees are only entitled to be paid at 2/3 their regular rate. Same thing for employees caring for someone who has been advised to self-quarantine. They can get up to 2 weeks paid at their 2/3 rate, not more than $200 a day. And employees who have to care for a child, they get up to 2 weeks of paid sick leave plus 10 weeks of FMLA leave, and that's all paid at the 2/3 rate, up to $200 a day, a maximum of $12,000 for the total 12 weeks. Okay, any questions? Okay. Remember, and this sometimes gets a little bit lost in the weeds because we're trying to interpret this and we're trying to look at what the law provides. But a very basic thing that everyone needs to keep in mind, that employers who are forced to reduce or cease all their operations may have to terminate employees. And if you've got an employee, let's say you're not ceasing your operations today, and you may have employees that are out on sick leave as of today, but if you have to terminate your operations next week, then any leave that any employee is on also is terminated. If an employee is no longer going to have a job, that employee is no longer entitled to be paid any paid leave under either the emergency FMLA or the paid sick leave. But terminated employees can file for unemployment compensation, and that is something that is going to be enhanced by the CARES Act. And hopefully the termination is only going to be temporary, in which case when you are able to bring your employees back and there is a job for them, you want them back, they notify you that they want to come back, then they can go off of unemployment compensation. But the key is balancing the employer's need to be able to keep its staff, allow its staff some leave if they are sick or need to take care of their child, with doing business. Because at the end of the day, if an employer can't do business, then they're not going to have a need for employees. There is always a risk that when you terminate an employee who's on an existing leave, that they're going to deem that to be retaliatory, and they're going to go contact an attorney and they're going to try to sue you for retaliation. There's really nothing you could do about that. People are always going to look for a way to sue their employers. The only thing that I can recommend to all employers who are out there is make sure that you properly document any actions taken with respect to your employees. And if you need to back up an employment decision with a termination decision with proof that you've reduced or ceased operations, make sure to have all of that proof lined up so that down the road, if it ever comes to pass that you are involved in any type of legal claim, that you have good, sufficient information to document what's going on. A lot of times, employers don't necessarily think about that until after the fact. I'm telling you that to the extent that you are dealing with employees who may be terminated, it's a good idea to keep that in mind, that documentation is critical to the process. Okay, you remember I talked to you about exemptions. So the new laws are applicable to employers that have less than 500 employees, which includes a lot of employers. But there is a way to secure an exemption from the Act. There was guidance that was just published by the Department of Labor. It was either 2 or 3 days ago. And the guidance provides that an authorized officer of the business can certify that the cost of providing sick leave or expanding medical leave, family medical leave, would be just too excessive and cause the business to cease operating at a minimal capacity. So that would require a certification that the costs are just too excessive. And I would recommend any employer that is seeking to secure an exemption to track the actual language in this guidance, because that's probably what the Department of Labor is going to be looking at in terms of whether an exemption is to be granted or not. The second reason, and these are alternative reasons, these are the 3 reasons that the Department of Labor has suggested for securing an exemption from the new Act. That the employee who is seeking this leave would entail a substantial risk to the financial health or operational capacities because of specialized skills, knowledge, or responsibilities. And this is similar to under the regular FMLA, where you have someone who is a key employee. The Department of Labor has not used that terminology here, but my reading of this is similar to what they look at for purposes of not allowing a key employee the rights under the FMLA Act. So if you have an employee whose special skills are so critical to your business that you cannot afford to pay them, you cannot afford to have them leave your employ, that would be a certification as well as to why you would not be able to allow them the benefits under the Act. And the other alternative reason would be that there's just not enough other staff available to do the work to be able to allow the business to operate at minimal capacity. If you're operating with a skeletal staff and you really can't afford to let anybody else go because every person is performing the jobs of 5 other people, that would be a reason. So these are what the Department of Labor has suggested as the factual basis for claiming an exemption. And there's more that I can talk about on this exemption, but I see we have a couple questions. So let me see if we're gonna be able to deal with them now.
I don't have any new questions that came in.
Oh, okay. All right. Let's go to the next slide. So as we sit here today, I don't know how long that exemption process is going to take. For example, if you're an employer and you provide and you submit to the Department of Labor a request for an exemption, it's probably not going to be turned around quickly. And there's no guidance as to what employers are supposed to do in the interim. You know, my suggestion is probably if you're seeking an exemption, you should probably not be paying for any type of leave. And if in the event the exemption is granted, you could pay after the fact. That's how I assume that things are going to go, but I can't tell you that for certain. Regulations are supposed to be issued. I'm going to continue to keep everyone apprised of what's going on. And let me just let you know that anybody who is on the webinar today and would like to be included in my email blast where I give updates about all types of employment laws, I'm glad to include you and will be happy to update you once these regulations are issued as to how the exemption process is actually going to roll out. And if there's any new developments in terms of interpretation or guidance that's offered by the Department of Labor. But the Department of Labor has said that they're not going to take any actions to enforce the act until April 17th at the earliest. And I think it's probably not going to be, I don't think it's going to happen until far later after April 17th, because I think that the Department of Labor, like many federal agencies, are probably just inundated at this moment. But what the Department of Labor has said in its guidance is that, and I'm going to quote here, encourages employers and employees to collaborate to reach the best solution for maintaining the business and ensuring employee safety. And this to me signals that the Department of Labor wants employers and employees to work together to try to allow employees some payment for being out on either FMLA or sick leave, and allow the employer to be able to pay them. It's not a perfect system. It's a system that's in place. And unfortunately, I've seen it too many times that employers who try to do the right thing end up actually doing the wrong thing when they try to bend over backwards to help employees. If you really got a situation where you just don't know where to turn or you are seeking guidance, I urge you to contact legal counsel. And again, document, because all of this is going to come back and be necessary down the road should litigation ensue. Obviously, you need to operate with the spirit of cooperation, but if you cannot, then you need to apply for the exemption. As I mentioned before, and the overall theme is the new rules, the law is not intended to put employers out of business. They're intended to protect employees who, but for the impact of the virus, would be available to work and, most importantly, actually have a job. So it really, the law is trying to strike a balance between allowing employees some flexibility to be able to take care of their children, take care of themselves, but also to allow employers to continue doing business. I see a question.
Someone just asked if they will be receiving copies of these slides. So just a reminder, this whole presentation is recorded and we will be sending a follow-up email with the link to the recorded presentation with these slides as well.
Okay, great. So next slide then, Sophia. Sophia? There we go. So I know someone asked at the beginning about the posting requirements. Many of you, I'm sure, probably have these posters already in your workplace. So as with other labor law posters and the workers' comp posters, employers are required to post notice of the act in a conspicuous location. And what I've recommended to my employers who have employees working remotely, they should distribute this notice electronically to their remote workers. I put a copy in the presentation of the poster in English. I can tell you that there is already a Spanish version, and probably other languages are going to be coming out as well. I just saw the Spanish a couple of days ago. So if you need the poster in other languages, a good idea is to go to the Department of Labor website and you can get that, or you can email me and I'll be glad to send it to you. Next slide, unless we have questions. Okay, so remember, you do not need to notify any persons who were laid off prior to today of the requirements of the Act. You do not need to share the requirements of the Act with job applicants. You do need to make sure that new employees have access to the poster, whether electronically if they're working remotely or posting in the employer's work site. If an employer has numerous work sites and employees are not obligated to go just to the main office and then go to the remote work site, it's recommended that you post it in all of the work sites. But for example, let's say you have a construction business where the employees come into work in the morning and get their orders for the day. If they are able to see the poster at the main office, the poster is not required to be posted also at the job site. So, I mean, there's no harm in additional posting, but I would recommend follow your normal posting requirements. Wherever you have posters, put the poster for the FFCRA. Any questions? Okay, let's go on. So I just wanted to very briefly mention, even though this is not part of the act, many of you, because we're in the city of Boca Raton, I thought that this would be a good idea to mention this about the city of Boca Raton order closing non-essential commercial businesses. And I've included the link, excuse me, the link for that order. It's only 4 pages. It won't take you very long to read. But when you read it, you're going to see that most of the businesses that are deemed to be essential versus the businesses that are not, well, they don't define businesses that are not essential. They define the businesses that are deemed to be essential. And there's 40 different categories. And just my reading of it is that these categories can be very broadly interpreted. So that you may have a business that probably falls under some essential category, or you may be working for a business that falls under some essential category. You know, I've been recommending to my employers that to the extent that you've got a business that you can have people working remotely, you should have them working remotely. The less that we've got going on, the less people have to be out and about and, you know, on the streets, in and out of offices, in and out of stores, the better for all of us. It's impossible to be home 24/7 because we all have needs to go to the grocery store, to get medication, et cetera, and so forth. But if you don't have to have your employees come to work in your office, that's what I'm recommending. Not every business can do that. And there's a lot of service businesses that absolutely can't do that. You have to know your business and know what you can do. But everyone really needs to self-regulate. Everyone needs to be doing our part to flatten the curve. That's the expression they keep using, flatten the curve, so that we're going to be able to get past this and that we're going to start to see the number of cases decrease as opposed to continuing to increase. But of course, the most important thing is for everyone to stay healthy and for employers to continue to be able to do business and that we can get past this. I see we had some questions, Sophia.
Can you hear me?
Yes, now I can.
Someone asks, we are an essential business. If we decide for safety to close for 2 weeks and pay our employees, will they still be entitled to additional sick leave pay?
What you're doing in that situation is you're deciding voluntarily to close the business. That employee is not taking advantage of any benefit. That is something, I'm sorry, any paid sick leave. You are actually doing that as the employer, which the employer has the right to do anything more generous than what the law provides. But any type of self-regulation where you're closing the office, that's not going to interfere with the employee's rights for paid sick leave or family medical leave. Any other questions, Sophia?
That was the last question for right now.
Okay, so let me give some closing advice. Go to the next slide, please. I think that everyone needs to keep in mind that these are strange times that we are in now, and we don't know when things are going to be getting back to normal and what normal looks like, because normal down the road may not look like what we knew it to be a few months ago. So everyone needs to recognize the need to be flexible. But for employers, it's particularly necessary to be flexible because unfortunately, the law puts burdens on employers that it doesn't put on employees. So for all the employers out there, I urge you to be flexible. But at the same time, you need to continue to reevaluate your business needs on a daily and a weekly basis. And you need to be prepared to change courses as the ongoing crisis develops. That last question was a perfect example. If an employer decides, look, you know what, we don't know who's coming in and out, we don't know what they're bringing into the office, what we want to do is we want to just close the office. We want to tell everybody that they've got to stay home for 2 weeks. We want to sanitize the office. We want to do everything that we possibly can to protect our employees and allow them 2 weeks to that, God forbid, anybody is sick, that they're going to be able to get over in the next couple of weeks. You need to continue to monitor the situation daily and weekly and be prepared to be changing courses as the need develops. Again, I can't stress this enough. Update your time off and your sick policies to reflect the new requirements under the Act. If you can have employees work from home and remain productive, you should have them do that. And hopefully the new CARES Act is going to make it easier for businesses to be able to function, to be able to get some financial relief until we're able to return to business as usual. And hopefully that's going to happen in the near future. That's all that we can think about right now, is hoping that we're going to be all back to work and back to our lives and seeing each other face to face in the very near future. But until then, we all need to stay safe and do our part to try to take care of ourselves and take care of each other. Did we have any other questions, Sophia?
No questions, but if any other questions do want to come in, we can do an open Q&A right now.
Okay, we can give it a few minutes. And again, if anybody, has any questions and they want to just, email me privately, that's fine. We don't need to share your specific questions with everybody. I'm happy to weigh in and try to help as best as I can. Any questions, Sophia?
Not yet. Haven't received any new questions, but like I said, this will be emailed with Miss Ellen's information. So if anything does come up later, please feel free to reach out.
Okay. Thank you all for taking time out of your very busy, very crazy, hectic schedules to participate today. I appreciate your allowing me this forum to do so. And I'm here for everybody. So please keep in touch.
We actually just had a couple questions pop in.
Okay, there we go. We spoke too soon.
Do you know if this law also applies to international workers under a H-2B or J-1 visa?
That is a great question. And I know exactly who asked that question because that's a client of mine. I do not know the answer, but I will find out the answer. It seems to me that if you've got employees that are working in the United States, it applies to those employees. I'm not an immigration attorney, but I know some great immigration attorneys, so I will definitely follow up on that. And if the person that asked that question could email me directly so that I can email them back, that would be awesome.
One more question. As a chamber employee, when I speak to members, can I tell them to call you as the questions get complicated?
Yeah, tell them to email me. Email is better because that office number, I'm not working in my office. I'm working from my lovely home right now. So they can email me and I will be sure to get back to them. And if they put their phone number in their email and I need to call them, I will be glad to do that.
Perfect. Well, thank you so much.
Okay, everyone stay safe. Thank you.
Awesome. Thank you so much, Ellen. We greatly appreciate it. I saw Sarah clapping. Sarah, do you have anything to say?
Oh, she gave me a thumbs up also. Thank you, Sarah.
Yes, she did.
This was by far the most informative webinar that I've sat in. I appreciate it tremendously. We appreciate it. I know you're busy, and when we called and asked if you would do this, you jumped at it, and we appreciate it. You are definitely the expert, and we might be calling you again if some things change and we can put another webinar together.
You always know how to get me, Sarah. I can't run away from you.
Okay. Thank you.
Well,
take care, girls.
Thank you so much again. We greatly appreciate it. Thank you all who've joined us at this informative webinars. Awesome. Stay tuned for future Zooms that are coming from the Boca Chamber. We have one tomorrow with Daskell Bolton. We have another one with Dean Danielle Gropper from FAU on Friday with our prime professionals. And we have some other stuff coming up next week, so stay tuned. Check the Chamber's website. Check out your email. Stay healthy, stay safe, and we'll see you soon. Have a great day.
Bye, everyone.